As of 2019, the expungement law in South Carolina has changed. In this video, we are going to talk about the changes that occurred for people who were convicted of crimes under the Youthful Offender Act, or if they weren't convicted under the Youthful Offender Act, if they were convicted during the time that they were ages 17 to 24, and they were convicted prior to June 2nd, 2010, they may be eligible. So what I have here, what you'll see me referring to is I've printed out the YOA section of the first offense conviction as a youthful offender, part of the expungement statute. And again, this must be a first offense for people who qualify under this section. They would qualify as a youthful offender, and if they were sentenced pursuant to the Youthful Offender Act, sometimes you'll hear that referred to in South Carolina as the YOA, and the defendant has not been convicted of any other offense, so you can't have anything else on your record, including anything that's out of state, and while during the time that you were serving the youthful offender sentence, including probation, parole, and for a period of 5 years from the date of completion of the defendant's sentence, including probation and parole. So it's very important that you understand the time period that applies here, that if this is you, then you can apply or cause someone acting on your behalf to apply to the circuit court, which is a certain level of court in South Carolina, for an order expunging records of the arrest and conviction. This is important. Any number of offenses for which an individual received under the YOA at a single sentencing proceeding for offenses that are closely connected and arose out of the same incident may be considered as one offense and treated as one conviction for expungement. That's really important because this is talking about the new expungement law effective in the year 2019. So if you were not eligible for an expungement prior to now, you may be eligible now, and this makes a really huge difference for some folks. So no person can have his or her records expunged under this section more than once, and you may have the person's record expunged even though the conviction occurred before the effective date of this section. And so that's also very important. And if you were eligible for a YOA sentence, or you weren't sentenced pursuant to the Youthful Offender Act, and you were between the ages of 17 and 24, so if for whatever reason you didn't have an attorney, or your attorney didn't know about the YOA Act, or your attorney knew and they didn't tell you about the YOA, and you somehow pled guilty or were found guilty as a result, and you should have been sentenced under the YOA, then you could be sentenced pursuant to these provisions. You would not be eligible to have the person's record expunged pursuant to the provisions of the section. However, a person who is convicted prior to June 2nd, 2010, June 2nd, 2010 is the date given here in the statute. If you were convicted prior to that date and was a youthful offender, as explained under and what the definition is of a youthful offender under the Youthful Offender Act in South Carolina, and that act is 24-19-10 Section D, you would be eligible to have your record expunged pursuant to the provisions of this section. So again, someone that would fall into the classification of someone 17 to 24 years of age. And then it goes into, however, this section does not apply to an offense involving operation of a motor vehicle. We know from other videos that I've done that operation of motor vehicle, those types of convictions are not expungible in South Carolina. An offense classified as a violent crime, and violent crime isn't like what you or I would think would be violent. It's actually classified in the South Carolina statutes under 16-160, and basically it's a host of violent offenses. Violent offenses could be classified as a violent offense even though there was no violence involved in it, and that's what I mean by a legal term. For example, a drug offense, drug trafficking is considered violent in South Carolina even though maybe no violence at all was used during the crime. So that would be not, if you were convicted of a violent crime, would not be applicable here. And then an offense contained in Chapter 25, Title 16, except as otherwise provided in 1625-30, so that has to do with domestic violence. And then the last thing that is not applicable to the YOA, of course, is an offense for which the individual is required to register as a sex offender in accordance to the South Carolina Sex Offender Registry Act. So I hope this clears up some questions about the new expungement law in South Carolina. I'm referring to it on a document here because I want to make sure I get everything correct. It's new to me, but I don't want the newness to make anyone shy away from it or wonder what's included in the new law. And I would like for everyone who's eligible for an expungement to reap the benefit of that, and especially if they thought they weren't eligible before, this new act in South Carolina for expungement laws is very important for folks. So for more information, head on over to my website at www.swilliams-law.net. If you found this video helpful, go ahead and hit the like button. Feel free to subscribe. And if you have more questions, my number is 843-607-9800.